months, arguably years, we have been teeing up some of these Supreme Court cases that were about to come down, or were eventually going to come down from this 6-3 conservative Republican court. And a big one dropped today. There are still two big ones that are extant, at least ones that we have talked about. The decision on Roe v. Wade, essentially, and West Virginia EPA case, which could seriously inhibit and corrode our administrative state. But today, there were 4 decisions, I believe, that were dropped down. I've only taken a look at one, but this is the biggest one, and it's going to have the most impact on the most amount of people, and will undoubtedly lead to both more people dying because they were shot and killed, and I think just a general sense of insecurity amongst the vast majority of Americans who do not see a legitimate reason for someone to be just walking around with a gun.
Yeah, and just internal domestic intimidation, a sense of that too. Like the vast majority of the guns that are going to be sold aren't going to be like people protecting themselves from like the authorities. It's going to be intimidating people in their lives.
That's exactly right. And I would also, I think if you follow that out too, it's going to inhibit free speech. Talk about cancel culture. The person who brings that gun to the bar and gets into an argument, probably going to win. But here are the basics. We've talked about this many times in the past. I'm going to repeat some of that. More than a century ago, that is more than 100 years ago, New York State imposed a law that basically said if you want to carry a concealed weapon for self-defense, you need to show a specific need for doing so. What that constituted, I think you can imagine. But you should know that about 65% of the people who go in front of or apply for that permit, a concealed carry permit, are approved. And there are about, like I say, I don't know, about 25 states that, maybe a little bit less, that have a similar requirement. Massachusetts, there's more. I can't remember exactly how many, but it's about 80 million people. And this law was challenged. 2 people challenging the law, Robert Nash and Brandon Koch, have license to carry handguns for hunting and target practice. But the New York authorities denied their request for unrestricted licenses for self-defense because officials said they could not show a, quote, special need for self-protection distinguishable from that of the general community. So, for instance, if you are, I don't know, maybe you're a DA and you've gotten a lot of threats, or maybe you've just gotten a lot of threats, or maybe you do some housing inspection, or maybe, I don't know, arguably you're a repo person. I don't know. But you need to show some reason why you are in more imminent danger than your average person in New York City or walking around in some other town. And they couldn't. Like I say, 65% of applicants were approved for an unrestricted license. This is according to a state analysis that was submitted to the court. Mark Joseph Stern on a Twitter thread basically says this expands the scope of the Second Amendment. And remember, none of this was an issue until 14 years ago in the 2008 Heller case. None of it. That's why there was a law like this for over 100 years in this country, because a conservative Supreme Court decided they were going to have a new interpretation of the Second Amendment. That's what's going on. They decided to have a new interpretation of the Second Amendment in 2008. And everything that is now happening with the Second Amendment is a function of that. One of the briefs mentioned, we have mass shootings. This is a problem. We want to limit guns and how many people can carry around guns in the city, let's say, or walking amongst us, or in a bar. Because incidentally, that's next. The next thing is, how do you inhibit people from bringing them into schools? Like, where's the logic here? If it is a right that cannot be restricted by the state, if you can't be told we need a legitimate reason for you to carry around a gun, well then, what's the point of a permit process?
Yeah, the Constitution says I should be allowed to defend myself, whether I'm at a preschool or CPAC.
We're going to see, it's just a matter of time, all permitting basically removed. I mean, I don't even know why. There may be no point in having permitting at this point. If you can't be restricted in any way by carrying the gun, but that will fall, and then like you will not be able to go into spaces. There will be no safe spaces, snowflakes. Sorry. But this Stern points out. Thomas wrote the opinion. Alito wrote a concurring. This little thing just gives you a sense of what kind of pissant Sam Alito is. Does the dissent, writing towards the dissent, think that laws like New York's prevent or deter such atrocities? Talking about mass shootings. Will a person bent on carrying out a mass shooting be stopped if he knows it's illegal to carry a handgun outside the home? Now, it's possible. It might make it harder for them. There may be tripwires that go off. And how does the dissent, he writes, account for the fact that one of the mass shootings near the top of the list took place in Buffalo? The New York law at issue in this case obviously did not stop that perpetrator. Just contemplate, just switch out this gun law for murder. The law against murder didn't stop this guy from shooting these people. Do you know what? The law against trespassing probably didn't either.
Death penalty didn't.
I wonder if this isn't a good argument for the nullification of all laws.
It's so clear, like, well, the problem with the New York law is that it didn't also ban those giant assault weapons.
Maybe there's an argument for more restrictions, not less.
That would be my reading.
And the bottom line is, Clarence Thomas says none of this is relevant. It doesn't matter. It does not matter. We have decided upon a principle 14 years ago that we have now pretended has existed since the founding of this country, since the writing of the Constitution. It just took us about 200 plus years to find it in the Constitution. Thomas's opinion, according to Stern, for the court suggests that judges may not consider empirical evidence about the dangers posed by firearms when evaluating gun control laws. It is wholly irrelevant if they are effective. It is wholly irrelevant if guns are a problem in society. They are a God-given, and by God-given I mean 5 conservative justices in 2008 right. They only may ask whether a modern regulation has some analog that is rooted in American history. This is just a bizarre assessment, particularly since in 2008, there was no law rooted in American history that said everyone has the ability, an unfettered right to carry a firearm. It just didn't exist.
And some like individual right to self-defense, which the Second Amendment doesn't even hint at with the well-regulated militia language. Not even a hint toward that.
Thomas overrules the two-step approach used by many courts of appeals when assessing gun control laws. Instead of placing an incredibly heavy burden on the government to prove that every regulation of firearms is part of the historical, instead, I should say, placing a heavy burden on the government to prove that every regulation of firearms is part of the historical tradition, whatever the F that means. I don't know what to tell you, but this was perfectly predictable, and more to come. More to come with the Supreme Court. And elections do have consequences, particularly, in some instances, they get you a 6-3 court by hook or crook. In some instances, it causes the president to try and overthrow the actual winner. So there are consequences.